Hello, my name is Fernando Dubovi. I'm an immigration attorney, and for over 19 years I have focused my practice in defending immigrants in deportation proceedings. Today I want to talk to you about what the immigration consequences for criminal convictions can be for non-U.S. citizens. If you're watching this video, you're probably one of two categories. You're either a criminal defense attorney who has a non-U.S. citizen client who is facing a potential criminal case, or perhaps you're a permanent resident, or you're an immigrant trying to get your residency and you're concerned about a pending charge and how it will affect your immigration status. Or perhaps you're already a permanent resident and you had a conviction from several years ago and you've already completed probation and done everything and you want to apply for citizenship, but you've heard that a prior offense may affect your right to citizenship. Or in some cases, you may have heard of family members who are permanent residents, who recently left the country, maybe for Christmas, to go visit family outside the U.S., and were arrested on returning to the United States at the airport or at the border because they had prior criminal histories. This video will explain to you the immigration consequences for criminal convictions and hopefully help you prepare in anticipation of a possible immigration problem should you get put in deportation proceedings. If you're a criminal defense attorney, the baseline is to try to understand your client's immigration status. Number one, are they a lawful permanent resident? Do they actually have their green card? If so, how long have they been a permanent resident? And then do they have any prior convictions that might have made them deportable before? In some cases, your client might be trying to get their residency. They might have an application filed through a family member, through their wife, through their father or mother, and they're in line to get their residency. Additionally, if you are a permanent resident and you have been a permanent resident since before you turned 18 and your father or mother naturalized or were already American citizens when you became a resident, you may in fact already be a U.S. citizen and not be exposed to deportation consequences even if you've had a criminal offense. This is called derivative citizenship, and it is acquired if before you turned 18 you were already a permanent resident and your father or mother was either a citizen or they naturalized before you turned 18. In that situation, you may only have a resident alien card, your green card, but in fact, you're already a citizen of the United States and you do not face any kind of deportation consequences. There are two ground rules to remember when trying to decide the immigration consequences for a criminal conviction. Number one, for defense attorneys and individuals, a deferred adjudication is a conviction for immigration purposes. A deferred adjudication is a conviction for immigration purposes. Now, there are situations where a defense attorney can tailor a plea and use a deferred adjudication to mitigate and sometimes erase deportation consequences using a deferred adjudication. But defense attorneys and individuals who have been in criminal proceedings and have received deferred adjudications and were told by their lawyers, rightfully so, that if you complied with probation and completed everything, that it would not be considered a conviction. It is not a conviction with the state, but it is a conviction with immigration authorities. The second rule to remember is that a suspended jail sentence is considered the same as an actual sentence imposed. So, if your client receives, or you received, 3 years TDC, 3 years prison, suspended for 3 years probation, then those 3 years in prison that were suspended will be considered the same as an actual sentence imposed. Why is this important? Because a person convicted of a theft offense or a crime of violence, like a domestic violence or a theft offense, a misdemeanor theft offense, a person who receives a jail sentence or 1 year or more for that offense, even if it's suspended, will now, for immigration purposes, be tried as having been convicted of an aggravated felony, and that person will face automatic deportation. For immigration purposes, there are two different categories of deportable offenses. First and foremost are aggravated felonies. If a person is convicted of an aggravated felony, they will be subject to automatic deportation. It won't matter if it's their first offense. It won't matter how long they've been in the United States. It won't matter if their wife and children are all U.S. citizens. If a person is convicted of an aggravated felony and is not a citizen of the United States, they will be subject to automatic deportation. Aggravated felonies include any murder, any kind of a sex offense, any kind of a drug dealing offense, conspiracy, possession with intent to distribute. These are all aggravated felonies by virtue of the offense themselves. Also, as I mentioned earlier, two other types of offenses, crimes of violence and theft offenses, become aggravated felonies if the court imposes a jail sentence of 1 year or more, even if that jail sentence is suspended. These are the list of aggravated felonies. The Immigration Act also lists other deportable offenses for which there may be waivers from deportations available. These offenses include assault, domestic violence, unlawful carrying of a weapon, simple possession of a controlled substance, theft offenses, also known as crimes involving moral turpitude, and some other crimes of violence. Additionally, persons convicted of helping someone cross illegally in the United States are also treated as an aggravated felon. This happens often in border towns, El Paso, Laredo, California, where someone helps a family member come into the United States illegally and is caught with alien smuggling. Perhaps you're bringing a cousin over for a quinceañera, but it's treated the same as if you were a coyote. And after you're convicted of the offense, you're then subject to automatic deportation for the aggravated felony. So what's my advice for non-citizens who either have a prior conviction for an offense or have a pending charge? Number one, if you already have been convicted of an offense and are a permanent resident, do not apply for U.S. citizenship without first consulting an immigration attorney on how that prior crime can affect your ability not only to become a citizen, but worse, wind up finding yourself being placed in deportation proceedings. Likewise, be aware, if you have been previously convicted of one of the offenses we talked about earlier, an old domestic violence offense, an old unlawful carrying of a weapon, or a drug offense, or a prior theft offense, even if you completed successfully your probation years ago, if you leave the country, when you return to the United States, the immigration officer at the airport or at the bridge can put you in deportation proceedings if they find out of these offenses. And we're seeing a lot more of these as the technology that's available to immigration officers at the border or at the airport can have them access all this additional information. The result is persons who for years have been coming across the border once a year to visit their grandmother have finding themselves being arrested by immigration because 10 years ago they might have pled guilty to a possession of a controlled substance, or a 10-year-old unlawful carrying of a weapon, or a domestic violence conviction. If you're a defense attorney, what can you do to prepare? First of all, if your client is currently not detained, but the client is not a U.S. citizen and is going to be subject to an immigration hold down the road, be proactive. Contact an immigration attorney with your client present to discuss, number one, what options you may have in a plea bargain stage where you can tailor a plea bargain that will mitigate or maybe even erase your client's deportation consequences. Or if it's possible that your client is going to have to plead guilty to a deportable offense, but he is eligible for a waiver, there is a lot that can be done proactively with your client to prepare his immigration defense so that if he is picked up by immigration, an immigration attorney can go to court with the immigration judge with an application for cancellation of removal, which is the defense from deportation for persons convicted of a certain offense. And by doing that, you can really decrease the amount of time that your client will spend in immigration custody. Now, what can you do if your client is detained and he has an immigration hold placed on him? It is critical to try to get the defendant, non-U.S. citizen defendant, in the hands of immigration while the charges are pending, instead of waiting to plead to the offense and then have them transferred to immigration custody. That is because in most cases, non-U.S. citizens who have not been convicted of crimes, even if they're here illegally and are facing pending charges and have an ICE hold, in most cases, those defendants will still be eligible for an immigration bond while the criminal case is pending. I usually counsel criminal defense attorneys in this situation to get the immigration attorney on board, pay the bond if the defendant is being held with an immigration hold, pay the bond while the charges are pending, get him to immigration custody. At that point, the immigration attorney can go before an immigration judge and ask that the defendant be released on an immigration bond. The client will then be released, and you will have a released client to focus on the defense case. There is a lot that can be done proactively as a defense attorney or as an individual, a permanent resident who may have had previous problems with the law that may make him subject to deportation, to prepare for this situation and mitigate and sometimes erase the immigration consequences or deportation consequences for non-U.S. citizens. My name's Fernando Dubovi. I'm an immigration attorney, and for over 19 years I have been defending persons in deportation proceedings because of these type of situations. If you have any questions, you can call us at our office, 214-948-7571, or reach out to us online at fernandodubovi.com. Thank you.